Hey, welcome back. This is The James Show. I'm your host, James Parker, on News Talk 820 WBAP, now on FM at 93.3. And one weird thing that's been going on in the background of your entire life is the intellectual property laws of your great country, America, have all this entire time been based on Mickey Mouse, the Mickey Mouse Protection Act, as we laughed about it. But it all goes back to Steamboat Willie, the first public iteration of Mickey Mouse. And look, here in like the broadcast industry, if you're doing a TV or movie or radio project, something in the public sphere, and you're going to use background music, one of the question was, is it older than Steamboat Willie? And that's what, and seriously, this is something that sounds like a joke, but this is what we have had to base some of these decisions on my entire broadcast career. And now that is changing. We have Steamboat Willie going into the public domain. They kept pushing back when the copyright would expire. It was supposed to expire in like 1955. Then it was supposed to expire again when I was in high school. And then it got extended to 2003 and then finally to 2023. And for some reason, I don't know why, they just finally stopped extending it, and now magic is happening. I have John Rizvi, a professor of patent law at a law school in Florida, Nova Southeastern Law School, and he's going to break this down in terms that I can understand a little bit better. Welcome to the James Show, John. Yeah, so explain what is different now in intellectual property law in America now that Steamboat Willie's copyright has expired.
Yeah, so and the expiration date was January 1st of this year, a little over a week ago. And because so many times in the past it got down to the wire before there was an extension, and you mentioned the Copyright Extension Act being made fun of and called the Mickey Mouse Protection Act, and that's because at one time copyrights were only valid for 14 years. And then there's an extension to 28 years, and then a 28 years plus a 28-year renewal. And then it went to life of the author plus 50 years. And now for corporate copyrights, it's 95 years of protection. And that 95 years finally came up on January 1st. There were no further extensions. So the original version of Mickey Mouse, referred to as a Steamboat Willie version, is now part of the public domain. And anybody can use it without getting a license from Disney.
See, we got a little taste of this because Winnie the Pooh is a little older than Steamboat Willie, so his copyright expired, and we had that weird Pooh killer movie. And is that a portent of things to come for Mickey Mouse?
Yeah, well, I certainly hope not. That movie, the Winnie the Pooh's friends went feral, and they started eating. It was horrible. I mean, I can't even imagine the impact on Disney's image and the financial impact if something similar were to happen to Mickey, and it is. In fact, there's been two announcements of horror versions of Mickey Mouse that have already come out. The one saving grace, in a sense, is that there's a more recent version of Mickey Mouse that has not expired, and many people may remember that's the version you'll see if you visit the theme park with the white gloves and the red shorts. That version of Mickey Mouse is still under copyright protection. Not for long, though, about a dozen or so more years. January 1st of 2036, that version is expiring.
So that's not too far away. When that happens, can someone else just open their own Disney World with all the Disney characters without having to pay off Disney?
So, well, not all the characters that are part of the public domain, they would be able to use. An important distinction, though, is that trademarks, as long as companies take the right steps to renew trademarks can be renewed indefinitely. They never expire, and Disney is adamant about making sure that the trademark rights, the branding rights to Mickey Mouse have not expired. So
what's the difference there? So I could use Steamboat Willie in a cartoon but not as a logo?
You can use Steamboat Willie in any fashion where you're not confusing consumers that there's that you're Disney, or that there's some sort of license or affiliation or endorsement by Disney. In that sense, the more horror your film is, the less likely people are to assume that it's somehow associated with Disney. So it's almost as if the law is providing an incentive to not have the character remain in character of Mickey Mouse. And the more horror-like the character becomes, the less likely there is to be confusion. Now, your example about a theme park, people may assume a theme park that uses Mickey Mouse or Steamboat Willie is somehow affiliated with Disney. So their brand will protect them there. If there's T-shirts and merchandise, the branding, the trademarks will protect them. As long as but if the company makes it clear that if they're not affiliated with Disney, and sometimes you'll see disclaimers of that sort, and that may be sufficient, and then you could have merchandise with Steamboat Willie on it, as long as consumers don't believe they're buying a Disney product.
Well, Professor, I've been interested in this case because if it's going to stay at this time period, then as the years go along, we're going to see Batman come into the public domain, and then Superman, and then so many of these other characters. We'll get all the way down to like Transformers and Optimus Prime and He-Man. And I think that, generally speaking, that's going to be good for culture. That's going to be good for entertainment. That's going to be good for many industries across the board. Am I just too optimistic? What do you say? We only got like 30 seconds here.
Yeah, so that's the whole purpose is to incentivize creative improvement or changes. I don't know if some would consider horror versions of these to be improvements. Like Bugs Bunny is not that far off. Bambi, Peter Pan, and as you mentioned, Batman, Superman. But it depends on the commercial success. Like, is the public going to get weary if the Winnie the Pooh movie actually did pretty well? But at some point, is it going to become old news, and people are not going to rush out to the theater to see the latest horror version of a copyright that they've known to love? And if the public's not interested, then hopefully we'll see a slowdown of these types of works.
All right, Professor John Rizvi from Nova Southeastern Law School in Florida, thank you very much for explaining this new era of intellectual property law that we all live under in America.